Hello, everybody. Welcome, everyone, to the seventh offering in our Scholars in the Square series. It's good to have people here in person, on Zoom, and also in the future through YouTube. After a 20-minute talk by Neil Montgomery, Dr. Abigail Eisenberg from our political science department will join me for a 20-minute conversation with Neil, and then we'll spend our last 20 minutes in an open discussion. Our speaker today is Neil Montgomery, who's a grad student fellow at the CSRS this year. Neil is with us during the last year of his PhD, or what we assume is the last year of his PhD in our political science department, where he's working on a project related to his lecture this evening. He completed his MA in political science at McGill in 2019, where he looked at the apology the Canadian state offered to Indigenous people in 2008. Now, some of you may have noticed that each week I try to not just read the territorial acknowledgement as a kind of a standalone statement, but to integrate it into my introduction of the speaker. Sometimes it's more challenged than other times. This time, the speaker's research and topic dovetails perfectly with the spirit of the acknowledgement. I think you'll find that Neil's interests in the place of culture, religion, and spirituality in Indigenous and non-Indigenous approaches to Canadian constitutionalism helps all to acknowledge and respect the Lekwungen peoples on whose traditional territory the university stands, and the Songhees, Esquimalt, and Wasanish peoples whose historical relationships to the land continue to this day. And so please join me in welcoming Neil Montgomery.
Thank you again to the centers, Paul, Rachel, Scott, Mariko is not here, everyone for coming. And I'm really looking forward to our conversation today and going into the future. Okay. So the motivation of my dissertation project as a whole, which this presentation is only a part, is what I continue to perceive as an incongruity in Canadian politics, in Canadian law and constitutionalism, and Canadian contemporary culture more generally. On the one hand, over the past 4 decades, there has been a growing recognition that Canadian history imposes certain obligations on every Canadian. Beginning largely in the 1980s, the Canadian state and Canadian society has been called to account for a number of historical injustices, including the discriminatory Chinese Immigration Act, repealed only in 1948, the internment of Japanese Canadians during the Second World War, and more broadly, the unjust treatment of Indigenous peoples in Canada over the past 2 centuries. These cases and others indicate that historical consciousness plays a significant role in contemporary Canadian culture and will likely do so for the foreseeable future. On the other hand, and again, largely since the 1980s, history has played a declining role in Canadian popular consciousness, particularly in the constitutional domain, with which my work is concerned. Canadians have been reticent to point to historical factors when articulating their contemporary identities. In 1982, Canada patriated its constitution through the Constitution Act 1982, severing ties with the United Kingdom and introducing the Bill of Rights, amongst other things. The Charter of Rights and Freedoms is that Bill of Rights. And the severing of ties was described by patriation's key architect and then Prime Minister, Pierre Trudeau, as achievements of the purest liberalism. In contrast to the United States, where even liberal Supreme Court justices assert that we are all originalists now, and the historical Constitution is treated with at least rhetorical deference, in Canada, it might be said that we are all living constitutionalists now, as what has been described as the living tree of the Canadian Constitution is meant to develop not only out of, but somehow past its historical origins. So one might think that there's no incongruity between these two positions, or these two perceptions that I have. That the recognition of historical injustice might just require us to return to history only to overcome it in the present. Calls for state apologies, reparations, and legal settlements certainly seem consistent with this notion or this approach to history and historical injustice. But I think this desire to overcome history seems obviously problematic when considering Indigenous state relations more generally. In that realm, history is not meant to be overcome, but remembered for its own sake. In that realm, history itself serves as a form of contemporary justification, both in the particular case of Indigenous rights that my dissertation is concerned with, but also more broadly in terms of the relationship between Indigenous peoples and contemporary Canadian society. So today, I just want to talk about this last aspect of Canada's return to history, at least in my comments, but I'm happy to discuss more broadly in terms of the of how Indigenous rights have been justified historically by the contemporary court, and of how religion can help us make sense of this turn to history. So as will become clear today, I want to treat the Canadian Constitution as a cultural form, which Ben Berger, who I understand is a good friend of the center, or at least many people here, describes as, and here I'm quoting, an interpretive horizon composed of sets of commitments, practices, and categories of thought that both frames experience and is experienced as such. Two of the most important elements making up the Canadian Constitution as an interpretive horizon are history and religion. And part of my project is meant to show how historical arguments were once grounded by religious categories of thought, and that turning back to these religious categories might help us make better sense of how we might think of a cultural match between the lived experience of Canadians, of Indigenous peoples in Canada, and the Canadian Constitution. Now, in 1982, Canada not only patriated the Constitution and introduced the Bill of Rights, but also recognized and affirmed, and here I'm quoting again, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada. Now, note that Section 35, where Indigenous rights are guaranteed, is separate from the rest of the Constitution, including the Charter, by design, and after much struggle by Indigenous peoples themselves, with Section 25 protecting Section 35 from Charter challenge. Over the next several decades, the Supreme Court of Canada went to work on defining these rights, and by the late 1990s had made significant progress. The central aspect of Aboriginal rights that I want to talk about today is how the court differentiated them from the enumerated rights of the Charter. Unlike Charter rights, which the court grounded on the inherent dignity of all Canadians, the court found that Aboriginal rights were grounded on the fact that, using the language of the court, Aboriginal people are Aboriginal, that Indigenous peoples were already here when Europeans arrived. The purpose of Aboriginal rights was therefore to secure this historical fact, not transcend it in the present, and therefore hence the incongruity that I see or that I perceive. Now, one way that the court sought to secure this fact of Indigenous preexistence was to justify Aboriginal rights historically. The next several slides show the sort of language the court uses to discuss these rights. Parts of it are quotes seen at trial, and parts of it are the court interpreting what was presented at trial. Now, embracing the claims of Indigenous peoples to have existed on these lands from time immemorial, the court turned to a notion of time immemorial rights that has long existed in the common law. This approach ensured that findings of fact would be central to the elaboration of Aboriginal law. In order to prove an Aboriginal right, Indigenous peoples would have to prove that a practice, fishing, gathering lumber, hunting, was a distinct element of their particular culture, dating before the assertion of Crown sovereignty. In order to prove Aboriginal title, Indigenous peoples would have to prove exclusive occupation, again dating from before Crown sovereignty. In other words, historical continuity from time immemorial would justify a contemporary right. This way of approaching rights raised two particular questions that the court has struggled to answer. Why was the moment of Crown sovereignty so important for the justification of Aboriginal rights? And how was continuity expected to be proven, given that sovereignty could in some cases be dated back to the 16th century? It is this latter question that I focus on, where the religious or theological dimensions of law come more explicitly into play. As history ceases to be empirical history, or at least empirical history as we tend to often understand it, and becomes a cultural form, more open to what we might call re-enchantment. Okay. Now, as mentioned earlier, time immemorial rights were not invented with Aboriginal law, and neither was the difficulty of proving it. Throughout England in the late medieval period, time immemorial rights were regularly invoked to prove possession, the standard approach to which merely meant beyond the memory of any living individual. In the 17th century, however, claims to time immemorial rights became more explicitly ideological, pursued for partisan purposes, with parliamentarians attacking royalists, royalists attacking parliamentarians, and radicals attacking them both, all claiming continuity with the sometimes English, sometimes British, sometimes Gothic or Anglo-Saxon ancient constitution. But they all share this language of historical justification. Perhaps the most influential conception of time immemorial rights from this period was provided by Edward Coke, who argued from somewhat contradictory premises that one, the common law found its origins in the ancient Britons, but two, that empirical proof of such origins was lost in the mists of time. Despite his broad influence on the development of the common law as a coherent tradition, Coke was almost alone among the early common lawyers in interpreting time immemorial rights literally. Despite having access to and regularly citing evidence, empirical evidence that proved the contrary, for Coke, contemporary rights just were historical rights, both declarations of what the law actually was in the past, as in the present, and therefore in time immemorial. Contemporary reforms were merely clarifications of what had already been the case for Coke. Somewhat paradoxically, the contemporary was thus proof of the historical, and the historical itself justification for the contemporary. And in more skeptical words, maybe contemporary rights just justify themselves. Okay. So in my work, I argue that what made this conception coherent or a little bit less paradoxical for Coke was not what has been described, and I apologize to the lawyers in the room, but as his lawyerly approach to history, but instead how his conception of law was thread together with religious influences. This can be demonstrated, I think, by showing how Coke's theologically influenced legal theory was a direct mirror of the legally influenced theology of Richard Hooker, perhaps the most influential English theologian of the 16th century. For the theologian, as much as the common lawyer, or this particular common lawyer and this particular theologian, the status quo of contemporary customary practice was merely a reflection of the deeper nature of all things. To the extent that everyday social interaction could be said to be ordered, this was only so due to its participation in a more fundamental constitution, both eternal and divine. As Cook noted in his reports, in such diversity of things, the diversity of everyday kind of customary practice, proceeds only from God, the fountain and founder of all good laws and constitutions. Here, Cook merely echoed what Hooker had earlier argued, that, and here I'm quoting as will become obvious with the language, there can be no doubt but that laws apparently good are, as it were, things copied out of the very tables of that high everlasting law, not as if men did behold that book and accordingly frame their laws, but because it worketh in them, because it discovereth and, as it were, readeth itself to the world by them, when the laws which they make are righteous. So for Hooker, as for Cook, this divine understanding of time immemorial custom, and therefore time immemorial rights, was present in action flowing from both tacit and explicit knowledge, the unity of which was based on a Pauline call to do everything for the glory of God. Regarding implicit knowledge, Hooker argued, here I'm quoting, that God must be glorified in all things, and that the actions of men cannot tend unto his glory unless they be framed after his law. By that which we work naturally, as when we breathe, sleep, move, we set forth the glory of God, as natural agents do, albeit we have no express purpose to make better end. And again, regarding more explicit knowledge found in natural reason, that without written law, men carry written in their hearts the universal law of mankind. Again, evoking Pauline sentiments. As the examples of Hooker and Cook demonstrate, time immemorial rights could be proven within an early modern England only to the extent that that culture was broadly participant in a shared world of divine inspiration. As the history of the common law shows, however, this culture was not to last. Coke is largely remembered as one of the first chroniclers of the common law, but his literal notion of time immemorial rights was short-lived. First, Francis Bacon, his contemporary, then Thomas Hobbes, David Hume, Jeremy Bentham, and others would orient the common law tradition away from history and custom and towards a positive conception of law as made by authoritative institutions rather than discovered or found in nature, in the divine order. As the more recent history of Aboriginal law also demonstrates, we still lack such a coherent story of time immemorial rights as the early moderns had. And I think this is to detriment of Indigenous peoples in Canada and the interpretation of Aboriginal rights. Evidence of this lack is perhaps the most lauded case of most recent cases in Aboriginal law, Tsilhqot'in Nation v. British Columbia, where the Supreme Court recognized Aboriginal title for the first time, accepting the nation had occupied their lands from time immemorial. This recognition of Aboriginal title, however, was somehow incomplete. Insofar as the court recognized the title, it simultaneously undermined it by laying out a test through which British Columbia could infringe upon it. In the unanimous judgment, the court found that allowing interjurisdictional immunity might lead to a legislative vacuum, might make it difficult, if not impossible, to deal effectively with problems such as pests and fires, a situation desired by neither federal or provincial government. Now, as numerous critics have pointed out, the assumption here seems to be that without federal or provincial law, there is no law at all in Indigenous territories, or at least no law with sufficient regulatory capacity. And this is somewhat ironic, again, as many critics have pointed out, given that the case was about the nation kind of preventing logging on their territory. But what I want to point out is that this approach, the court's approach in this case, also speaks against the approach to the common law I've just described. That is, analysis from a settler colonial perspective only gets us so far. Missing is the sense of deference to everyday custom that characterized the theories of Cook and Hooker, that where there is customary order, there is law. That a constitution is a cultural match with its society, and to the extent that it is not, it will wither away and cease to be effective law. So history and religion both matter for Canadian constitutionalism because they both bring coherence to our world of experience. Both help us show that constitutionalism is not merely a technique by which government can be limited by law, but a story of order and justification that helps us make sense of the world and how to act within it. The nature of Canadian secularity might mean that this broader, perhaps enchanted coherence is irredeemable, but Indigenous state relations have shown that its relevance to the contemporary period is at least not lost and might be required to have a coherent approach to Indigenous state reconciliation. And I'll conclude there.
Hey, thanks. Maybe we can just move the podium up. Yeah, great. As now a former fellow of the center and friend of mine and the center's, Abigail will join us for some conversation. And I'm just here to kind of
move things along.
Yeah.
Move things along as you do.
Yes.
You're so good at it. So that's great. I'm so happy to be having this conversation in front of this wonderful center that I miss very much. I would love to be a third-time fellow if we changed the rules and allowed such things. But for now, let's talk about history and the Constitution. So one of the things, so there are two parts. Okay, so let me start broadly. So here's the problem with history, Neil. It's just like one damn thing after another, as they say, right? And so how is it when we look back, you want to orient constitutional interpretation so that it is more sensitive to the historical origins of Indigenous rights, but also other rights as well. But if we go back to history, it's not just about what happened in history, and it's not just about practices. It's always about us picking and choosing which of those practices and happenings are relevant. And so between the history and our choosing what is relevant from that history, the history is not doing all the work in the equation. So I'm wondering if you can tell me, like, that's a very standard objection to historical explanation, right? Which is, it's not about history. History is like every single moment, right? It's about us imposing meaning on history. So isn't that imposition of meaning on history just exactly what people in 1980 did when they turned the page on history with the charter and said, these are the values in our history that we're going to entrench and that we're going to give significance to?
Good, thanks. I think there are several responses I could give there. And I think I'll proceed kind of historically, right? And like when you read kind of discussions about the Bill of Rights prior to the Charter era, like the parliamentary discussions and more popular discussions, there is this sense that like very particular historical injustices required some sort of legislative and perhaps constitutional response. So that was Japanese internment. It was issues to do with religious liberty in Quebec. it was the Second World War, the Holocaust, etc. So people had this very definitive idea of what it was in history that required the legislature to react to. So when we get to the 1980s, it's not clear to me that that's still the case. Charles Taylor has this amazing essay, I think written in, I can't remember when it was written. Anyways, before, I think 1979, 1980, where he says something like, nobody asked for the Charter of Rights and Freedoms. But then 10 years later, or no, so it was a retrospect. So 10 years later, everyone loves it. Everyone has embraced it. So I think we need to have both of these ideas in mind, right? One being that these sorts of rights, statutory or constitutional, should somehow reflect society and their desires out of these historical moments. But then I think we also have to, yes, as you're saying, come to grips with the fact that the Bill of Rights, the Charter, any sort of development of rights in the future will probably be an elite-driven process where the elites are interpreting what rights we should have, are interpreting which history matters. And I think that's kind of inescapable because they're going to do that anyways. So the final thing I'll say in response to that is I think it matters more so once you fully kind of embrace the language of history, then you do have the kind of elite drivers of this process responsible to that history. So if Pierre Trudeau had justified the charter in somehow terms which the Canadian populace didn't accept, then I think we would have had a different kind of outcome, different appreciation of the charter than we currently have.
So one of the things that I recall happening in the charter, I mean, we'll talk about Indigenous rights cases in a second, but the cases that really stand out for me are the cases about religion. Edward Books and Big M. And in those cases, so one before the charter, I think, one after the charter, or they're around 1985 when it's around when the charter came into full force and the anti-discrimination clause, section 15, came into force. One of those decisions stated that, or reflected what people think was the historical view of religion, that Canada is a religious Christian country. And that if people want to close their shops on Saturday, that's perfectly fine, but they're going to have to close them on Sunday as well. And Big M overturned that and said no, that there was a dignity issue there, and that issue was emblematic in some ways of charter rights. I put that to you as, so there's a lot of things in history that people wanted to get rid of in 1982, that the charter was a turning of the page and getting rid of things that actually we couldn't get rid of because of kind of institutional drag. And that is, I'm just wondering what you think of that, and if that's just the wrong way of thinking about it. And especially with respect to secularism.
Right. So, I mean, I think the question would be, did people want to get rid of that? Certainly some people did. And I don't know the answer. That is a legitimate question. I don't know the answer. But we did have the legislature, the representation of the popular will, right? Who had enacted these statutes. And so in that sense, I think the legislature at that time would have said, if they didn't say, I think they probably did, right? That this isn't a religious liberty case, right? It is in the abstract sense, if we want to kind of separate out the purpose of religious liberty, right? But I think if it's a match between the given society, then I think that's what rights should justify, right? So the question would be, did Canadians at that point in history actually think that this was a violation? And if so, I think it's legitimate, but if not, then I don't think it is.
Oh, so that's actually really interesting because just to press on this before we get to Indigenous rights again, is that another justification for the charter was just this massive demographic change in Canada into a super diverse society. And a society that was going to embrace an ethical conception of multiculturalism. And that conception had been absent in the previous constitutional setup of Canada, which was mainly focused on Catholicism, Protestantism, and federalism. So that constitution wasn't very good for our purposes. The new constitution was meant to bring us into the 21st century. So do you think that because of its rationalism, its abstract ideas about human dignity, and it was somewhat of a failure?
That what was a failure?
That the constitutional change was a bit of a failure. Would it have been better had it looked for justification for the principles, its principles in our history? I mean, that just seems to me to be like a treasure hunt that is bound to fail. But I mean, let's just say, I mean, would that have been a better way of going about doing it?
No, I mean, this is the problem people have leveled against political theorists like Burke or Hegel, right? Is that once the revolution happens, the Charter Revolution, as people call it, and then Canadians embrace it, right? We can say that it was justified in retrospect because it came to be embraced by the people, right? And therefore, we're taking this retrospective look. But if we want to take the point of view from the 1970s, from the early 1980s, I think we'd have to say that I'm not sure that you'd say it's a failure, but I think you'd have to say it's illegitimate in some way if we want to have a very minimalistic democratic sense to our constitutionalism, right?
Okay, I can see that. So do I have time for another
6 or 7 minutes.
Okay, so let's talk about the Indigenous cases. So the one case that you didn't name, but you described was Vanderpeet, 1996 case in which Stolo, First Nation woman fishing without a license, says, I have fished here since time immemorial, and the court says, prove it. And they say there are two things that you have to show, as you said. One is that the practice predates Crown sovereignty, and the other that you have practiced it since time immemorial. The test failed, right? And the test partly failed because actually fishing was not done historically. It was, fishing had been done historically. She was selling fish. And so that was, and it was anyway, lots of stuff written about that case. It's a really interesting case. I've written about it myself. So you want to focus on the second part, which is let's just imagine, how could an Indigenous community prove its practices historically, right? But most people focus on the first part, which is, and it had to have been done before the Crown asserted sovereignty, because once sovereignty was asserted, the game changed. So, in fact, is part of your argument, I mean, I want you to discuss this a bit, because I know it's part of your argument, but to what extent is your argument about defeating the legitimacy of that first requirement? That is, that Crown sovereignty becomes the sort of the point at which after crown sovereignty, the game changes. So if you do a practice after the crown has asserted sovereignty, sorry, you have to abide by the law and the crown can change the law. But if you did it before crown sovereignty, crown asserted sovereignty in wherever she was, I think in British Columbia near on the Fraser. If you did that before and you can prove it, then you have a case. So what do you think of the relevance of crown sovereignty in the work you're doing for Indigenous cases?
I mean, I think part of this story about re-enchantment that I'm trying to tell means that in some cases, the assertion of crown sovereignty doesn't actually matter. I'm sure the actual lawyers in the room can tell me about this, but I mean, in like the case of the common law, when time immemorial rights are kind of asserted, that was generally just meant back to before 1189, right? Which is Richard the First, I think. And that was a very like abstract sort of thing, right? Like, as I said, that wasn't actually the way that cases were judged, right? It was just beyond the living memory of a person. And with other sorts of common law rights, we get very kind of particular years to justify claims, right? 5 years, 20 years, 20 years, 25 years. One of the justices in Vanderpeet, I believe, suggested that this sort of time immemorial continuity could be something like 50 years, right? So in that sense, I actually don't think that this phrase crown sovereignty is necessarily important if we abandon this overly empirical approach to history, which I think we've partly done, and I think the Supreme Court has partly done, by accepting kind of like a more broad conception of evidence.
But then it reasserts itself in different guises in every single Indigenous rights case. So the Tsilhqot'in case is a case in point where they say, okay. You know, the Tsilhqot'in is a fabulous case because there's a murder where the Tsilhqot'in go and they hunt some people who they say do not cross into our territory. I can't remember the name. But they hunt them down and they kill them. And there's record of that. And it's on the basis of the record of that the Supreme Court of Canada says, okay, yeah, it looks like you did assert your sovereignty. You warned them. There's record of you warning them. You then killed them as you said you would because they would not listen to you. And so that was the way. But even though there is this recognition of the Crown says, yeah, but we can't have so many jurisdictions operating in one area. Isn't that just Crown sovereignty coming in through the back door? Just the Crown saying, we actually, it's all good, your history, but sorry, we're going to impose sovereignty anyway. I mean, is that what we should expect as in these cases where time immemorial is invoked? Just the assertion of Crown sovereignty in different guises anyway?
I mean, I think so. I think it's a losing battle to expect the Supreme Court of Canada to commit like what some people refer to as like constitutional suicide, right? To undermine its own authority, right? And many people have said this, I think, is I don't think we can expect the Canadian state and the Supreme Court, speaking for the Canadian state, to justify itself and its institutions, whether those are federal or provincial, otherwise. So I think we're stuck with Crown sovereignty because it itself gives justification for why the Supreme Court of Canada is adjudicating these cases. Right? So I think we need to go to the second question. I think it's more productive to avoid the sovereignty question and address the how question. Because I think these cases show that we've made way more progress on the how question
What do you mean the how question?
Sorry, the question is how Indigenous rights are to demonstrate continuity to the date of, or predating Crown sovereignty.
Oh.
Yeah, so the question of evidence, the questions of fact.
So one more question.
Yeah, and then we'll broaden it out.
Okay, so just to make sure I've got my mind around this the right way. So time immemorialism stands in contrast to a lot of very empirical ways of showing the connection of a practice through time. One of the great faculty members at U of Vic, Nancy Turner, who retired in the last 5 years or so, was an ethnobotanist, and she would show, she would give evidence at court about the boundaries between nations on the basis of the plants that were growing on each side of a boundary and the historical record. And that was used in Indigenous rights cases to show a continuity in cultural practices. How does time immemorialism, just for everybody, fit in with that empirical stuff? Does it displace it? Is it what it's made out of?
Good. I mean, I think those forms of evidence, I think, should already be taken seriously by the court. Right? So I think those sorts of evidence in kind of a like modern kind of orthodox approach to common law, approach to evidence, that is, sorry, could already take account of that, right? So then I think those forms of evidence would just fit seamlessly in to the court and their standard approach, and we wouldn't require this sort of more radical rethinking about what it means to prove possession, to prove continuity, right? So my focus on time immemorialism is more so on these cases where we need to open the common law up more to these Indigenous legal traditions that are less easily cognizable by the common law, but I think are capable of being.
Okay, thanks very much, Abigail. So now we'll just broaden the circle a little bit and give people in the room and on Zoom, and people on Zoom can ask via Rachel questions. So yeah, first one over here. Go ahead.
Yes. Thank you. It's a great presentation. Thank you for the conversation. So my question is going to deal with the issue of, we'll call it time. Is there kind of time memorial, obviously, is always about past, some fabricated time that may or may not exist, could be pointed to basically anything. But at the same time, you also brought up different ways of approaching the Constitution, so like originalism, which is also a past-oriented, living tree, which is very present-oriented, right? There's kind of just reinterpreting what was there for the contemporary moment. So you have past, present, but then there's also the future in time. So I'm wondering then how, and I'll keep this fairly vague and broad, open-ended, in reorienting this way to time immemorialism that you want, and then also kind of focusing more on the how problem, as you called it, will this affect moving into the future as like a beneficial project? Because if there's no beneficial project into the future, it kind of begins like, well, then who cares? Why do it anyways? Right? So that's my question.
Am I allowed to go back slides?
No.
Is that, yeah.
You are permitted.
My answer is the last quote from Hooker there. Right? Because corporations are immortal, we were then alive in our predecessors, and they and their successors do live still. Right? So in charter jurisprudence, right, in the earliest case of charter jurisprudence from the early 1980s, there is this definition of what a charter means, what a Bill of Rights means, what even constitutionalism means, right? And a key aspect of this is protecting individual rights into the future, right? Now, I am taking this approach which is in some respects the exact opposite of that, right? As you say, like bringing what was important to the past into the present so that we can both see ourselves as directed by the past and also see ourselves as being in relationships of obligation to the past, right? And I think that this is consistent with into the future, obligations into the future, right? But what I don't want to do, which I think is how kind of the court has taken things with charter jurisprudence, is to somehow abstract the future from the project of constitutionalism, from the kind of past and present, right? And I think this is a problem with a certain conception of common law rights, where, for example, we have an inductive method where we have the particular case of religious liberty, let's say, but then we abstract that principle of religious liberty from the case, and then we speculate in the future, this can be applied to a number of things, right? The kind of approach to the common law I want to take is that we need to be grounded still in those kind of particular past cases, right? So I think we can still see ourselves in relationships of obligation to the future, but I just wouldn't want those to be somehow abstracted from the present. Was that an answer?
Sure. It was an answer. Gary, I knew you were going to ask a question. I just feel it. As soon
So
as
if I
Richard Hooker
understand,
came
if I
up.
understand you correctly, you are making a very Burkean case here. Is that fair to say? I mean, even this quote from Hooker sounds to me like Burke had this in mind when he talks about culture as this relationship between the ancestors, the present, and the future, and you have this living set of traditions. So if that's fair, if there is a sort of self-conscious or implicit Burkean thinking at work here, I'm just wondering to what extent your project involves recovering some of the Burkean dimensions that are there in the original constitutional structure, right? Because I mean, I've just done a little bit of work on Dorothy McGee, and McGee was a huge Burkean, but also a very, very smart one. And he's sort of the father of Confederation. So, and my understanding of the Canadian Constitution was it always had this kind of Burkean element that the American one didn't. So is that a fair way of characterizing the project, or is that just too general?
No, I think that's an extremely fair way of doing it, of characterizing it. But unfortunately, like that is not in the structure of the presentation. So really, the whole dissertation is split into what I see as kind of two sections, or at least this is how it's been proposed, right? We have the kind of contemporary section where I'm dealing with charter rights, unwritten principles, written principles, Aboriginal rights. And then I have a more historical section where I'm looking at people like Richard Hooker, Edward Cook, Edmund Burke, J.F. Stephen, for their own kind of interpretations of town memorial rights. I haven't yet, and I don't plan to currently, but we'll see, connect that to earlier periods of Canadian constitutionalism. I'm really focused on how we can think about kind of dynamics post-1980 or post-1982.
That's really interesting. Because I mean, one of the places my question comes up is when I first read the indigenization statement in the new curriculum, new high school curriculum, one of the things I noticed is that it had to be, given the creature that it is, somewhat decontextualized, somewhat abstracted. But and it sounded so kind of Burkean in its general outlines. So to my mind, there is this kind of untapped possibility of thinking in the most general terms of indigenous cultures with this kind of tradition that I've always thought, but I don't know, I never knew how to formulate it, and it seems so vague and big. So I'm glad somebody else is thinking about it.
For the recording, could somebody give a thumbnail sketch of what you mean by Burkean?
Well, just the Hooker quote is very Burkean. Burke's reaction to the French Revolution was horror, because he thought it was imposing this kind of rationalized set of principles. and that he was arguing that what culture really is, that he ultimately argued it was unsustainable and it's kind of insane because it misunderstands human nature and human social relations, which have to be built on a continuity of past, present, and future. That in effect is what human beings are. Right? There's a sort of argument of human nature built into his case, which is quite different than the American situation, which is very Painite, right? And it's also these rational principles.
I would just say, just briefly, I think a lot of the work on the treaties, like the more actual historical work on the treaties, is quite interesting in this respect, right? Where these people were able to understand the relationship of the common law to Indigenous peoples, were able to engage in this treaty process in a way that was cognizable by both parties and embraced by both parties. And then we just lost that over the last 150 years. So I agree, this is part of my project. I'm saying we, I'm not sure if it is a we, but we were able to do this once. So I think we who see themselves as inheritors of this common law tradition can return there. There are untapped resources there.
I think you're right, but I think it's an uphill battle.
Could you, I wonder if one of the ways of responding to Gary's question is to reflect on the extent to which this is a reenchantment project. You're trying to create a space in the conversation for a more, as it were, enchanted, magical sense of history and connections to the future as well. Is that fair?
No, very fair. I think I'm mostly inspired by work that's going on over at the Indigenous Law Center. Rearticulating Indigenous legal traditions for the present, both in their own context, but then also speaking to how those traditions can be and have been in dialogue with the common law. And I think there hasn't been as much work, or I would at least like to see more work, which is why I'm doing it, on the other side, which is to say that non-pejoratively, right, these ways in which law is not this rationalized enterprise, it is this enchanted way of engaging in the world, are there in the common law. So
there's a rub there though with Abigail's question earlier about the kind of governing logic of secularism, which purports to be rational. But you're saying that implicit in that actually is these other forces that you're trying to drive to create space.
Sorry, could you restate that?
Well, does that seem like a fair rendering of your concern about secularism? But you didn't pick that up when she made that observation. If we think of the contemporary law or modern law tradition as being oriented toward a secularist orientation of the good and how to solve problems and balance interests and so forth, that it's got to be rational, not based on inherited privilege or magical assumptions or so forth, then is there a rub between that secularist orientation, the kind of rational Enlightenment era orientation, and what you're trying to create space for?
No, I mean, the question is like, is that true?
Yeah.
Like the rationalism question is the way that people like to talk about the common law. The question is like, does this represent what's actually going on, both historically and contemporarily? And I really like this. I'm not sure how explicit it is, but this aspect of the work of John Burroughs, again at the Law Center, right, where he uses this language consistently about the common law and shows how it's not this like rationalist enterprise, right? Like coming and planting a flag on the ground. Like what kind of practice is that? Like it's not a rationalist activity, right? It's very much a cultural kind of, I don't know.
God sent the queen, the queen sent the flag, somebody sent me, and I put the flag in. I mean, I'm teasing, I'm setting up a straw man in some sense, and I also very much appreciate the Van Berger's comment about it as a culture, right? So, because we can speak of cultures as having all kinds of ingredients, some of which are are rational, some of which are magical, historical, and so forth, right?
Mhm.
And so in that, it seems to me to be a one quite rich way to think about these issues, but John's as well, wonderful. So Paige, you had a question.
Yeah, I'm just trying to think about how I want to frame it. I want to sort of take it back to religion, because you said early the Constitution is kind of history and religion. And can I assume that when Hooker talks about the book and the book that we have framed our laws around, is he referring to the Bible?
Yes.
Yes, okay, so I assume so. Has that really gone away? Is there still some kind of institutional lag that you talked about? Charter tried to sort of move us beyond it. Not sure that it has. And if that lens still exists in the courts, even subconsciously, how is that impacting Indigenous rights?
Mhm. How much time do I have? Okay, so
I can stick.
I'm gonna give a analogy here. Okay, we'll see if it works. Okay, and then more explicitly, hopefully answer your question. So in the kind of history museum, Canadian History Museum in Gatineau, I can't remember the actual name of it is, right? There is this, what is it called in a museum? A display, interactive exhibit. Yes, there are new words for these things. And there's this display case, and like the exhibit is called From Time Immemorial. There's a subtitle with the Indigenous nation that this archaeology project was brought about with. And in this case, I can't remember what the tools are for. I think it has something to do with woodworking. And we see like a very like early tool, like it's a stone or something like this. And we see a progression slowly. And then the final one is a chainsaw or like a modern axe. This was like 5 years ago. I can't remember exactly what's in the case, right? But the question there, right? Like, first of all, the university or the museum is saying Indigenous peoples are still here, right? This nation is still here. But the question is that a different tool for the same purpose, right? Or is it the same tool for the same purpose, right? And I would say a similar thing to your question, right? Is this way of approaching the law, right? If we approach the law as somehow a tool, it was fulfilling some sort of purpose to do with human social relations in the 16th century and in the 17th century. And I think many of these purposes we still have, right? And it's the same tool. So what happens when you empty out the kind of like religious language or the religious conception that makes that tool coherent? I think in some cases the tool still works, right? But it's just less intelligible to us. And so the question is, when we get to these crisis points, which in many cases, that's what law is, that's what a case is, right? These are these crisis points. I think often we're shown that we can't actually explain what's going on there. How do we explain time immemorial evidence? Like, it's very hard for me to wrap my head around, right? And I think if I did have
some people on like the Supreme Court of the United States might equate time immemorial with God, with a very Christian God. That's how they would explain it.
Yeah. So if we had more explicitly religious, a more explicitly religious Supreme Court, or a Supreme Court that was more comfortable putting religious argumentation into that, I think if they want to be consistent, I think it would open the door to greater reconciliation with Indigenous peoples and Indigenous legal traditions. But justices are, rarely consistent. So,
Thanks very much. We have an opportunity for one more question, if there are any. No? Yeah, please.
It's outside of your field perhaps, and so this might not be an unfair question, but one of the things as somebody who's grown up in the political discourse of, I don't know, more and since, when I started looking at doing historical research, was how common the phrase time immemorial comes up by Indigenous speakers going back, certainly 19th century, I do BC, but I think earlier in other parts of the continent. And I'm wondering if you have a sense of where Indigenous people who are engaging with Crown law historically, so 19th century and earlier, are picking up that specific language of time immemorial. So before today, I didn't realize that was a specific category of common law rights in it, and I wonder if that's an intentionality there. But I'm curious if you've done any research in that area or come across anything about it.
Good. So I mean, I haven't done more historical work,
Yeah.
but the consistent reference seems to be, and someone is going to need to help me out here. 1910 Royal Commission on, I can't remember the name of it, but it's something like Aboriginal reserves or something.
Kind of, right.
Yeah, exactly. Where they go to the Nisga'a in British Columbia, and that's where the language comes from. And then we get that repeated in Calder.
There's earlier. I you need to find the references, but it's mid 19th century, like 1850s, 1860s in BC. I think we're using like, or the colonial authorities who are writing down the speeches of chiefs and things are saying, are using the language time immemorial. And so there's something going back to that I'm curious about.
Wouldn't it be interesting to see what the translation was like, you know,
Yeah.
how that term was rendered as time immemorial,
Yeah.
to ask Indigenous language speakers, you know, what was that metaphor like for you?
Exactly, yeah.
Super interesting. That's a great way to end. Thank you very much for that great question. Thanks, Abigail. So tune in same time next week. Andy Muchen will be talking about the Dairy Sisters, America's Yiddish Sisters. All right, and that'll be the last of our Scholars in the Square. This year. Thanks, everybody.